Hey, good afternoon, folks. Today I'm going to be talking about changes to the Workers' Comp Code, and specifically HB 442, which made this change as effective 9/23, 2022. And the thing I'm going to be talking about is the change that they made to 4123.01, the workers' comp definitions, because they included something relevant specifically to folks who work from home. So if you read 4123.01 and you go down to 4 or C4, you'll notice that this is a definition for injury, and it basically says the following. Injury includes any injury, whether caused by external accidental means or accidental in character and result, received in the course of employment and arising out of the injured workers or injured employees' employment. And it specifically states injury does not include, and it has numbered categories. And if we go down to number 4, this is the thing that's relevant to work from home folks. So it says this would not be an injury. So an injury or disability sustained by an employee who performs the employee's duties in a work area that is located within the employee's home and is separate and distinct from the location of the employer, unless all of the following apply. So if it happens at home, in an area and it's separate and distinct from the location of the employer, I don't know when it wouldn't be. Maybe if you're, I don't know, you live at work. I don't know, but so it wouldn't be unless all of the following apply. So the employee's injury or disability arises out of the employee's employment. So this is basically the workers' comp. They have these two things arising out of and then the course of, and that's kind of, that needs to happen. But frankly, they kind of seem to mean the same thing to me. I don't know, you're doing work for work. So the employee's injury or disability arises out of the employee's employment. I don't know, you're at home and you work as a secretary at home and you're doing whatever your documents for your employer. And then B, the employee's injury or disability was caused by a special hazard of the employee's employment activity. I don't know how this is going to be interpreted, and I'm looking at, when I look at these things, I look at these full commission orders, and I didn't see anything that referenced the new changes. I don't know what a special hazard of employee's employment activity would be if you're, working in your home office. I'm not really sure, because usually special hazard, that's like code that means something within workers' comp, and usually the special hazard is the most common place you'll find is in the going and coming rule. It's an exception, and essentially stands for but for the employment, the employee would not have been at the location where the injury occurred, and then the risk is distinctive in nature, quantitatively greater than the risk common to the public. So that's for the going and coming rule, not necessarily how this needs to be applied to working from home, but essentially when it's applied to the going and coming rule, remember it says that if you're driving to work or you're driving from work to home, from home to work or from work to home, if you get in a car accident or something, that's not a workers' comp injury generally. And one of the exceptions is a special hazard exception that I just mentioned. And an example of that would be that they've used is like somebody, well, the case is, I don't remember what the case name is, but the person, to pull out of this work, you have to go against traffic, and the person got in a car accident. So in that case, that special hazard exception applied because there was a quantitatively greater risk because you had to go against traffic because of that particular location. I don't know how this is going to be applied to the home injuries, because unless you're welding in your home garage or something, I don't know what, like you trip over your printer or something. Is that a special hazard of the employment? And then the question is, didn't you choose to put that printer on the ground that you tripped over? I don't understand how the employer would be responsible, and I would assume that that's the argument they'll make. But so that's B. And then the C thing, the employee's injury or disability is sustained in the course of an activity undertaken by the employee for the exclusive benefit of the employer. So I guess what they're trying to go after there is you're not, going to your kitchen to get tea and you trip over, again, the printer, I guess. I don't know. I'd be curious to see how this plays out. But I think the employers were not crazy about having to pay for claims where people are like falling down their stairs or, again, tripping over printers, things like that. So I don't know where I sit on this. Obviously, I represent injured workers, so I'm going to be inclined to be on the injured worker side. But I don't know. I think to a certain extent you should be responsible for if you're working from home, you need to be responsible for the way your office is set up, and if you're doing office work, I don't know. I think it'd be kind of weird to file a claim. Again, you're walking up the steps or walking down the steps to your home office and you fall, and then I don't know. And then you try to claim that I was going to my work office and I got a knee injury. Are we going to be arguing that the going and coming rule applies at that point? Because from the bedroom to the home office, well, the bedroom is your home, kind of for that example, and then the home office is work. And so from going from your bedroom to your home office until you get to the home office, that's the going and coming rule applies. I don't know. I just think you're going to get in weird fact patterns that are just kind of strange and kind of bend what really workers' comp is supposed to be about. So we'll see. But yeah, so that's the rule. Basically, it was kind of a thing pushed by employers because I guess a bunch of people were filing workers' comp claims for, I don't know, allegedly falling in their house. So here's the thing, though. This is different so don't get this confused. This is work from home. Don't get this confused if you have like a meniscal tear and you've had surgery and you're at your house and then your meniscal tear causes your knee to lock up and then you fall and you hit your head or you injure your knee further. So in that case, you're not really looking at it from this work from home. The injury happened at home, but you would be looking to say, hey, this injury was a flow-through injury from, like, for example, my knee meniscal tear situation. So that's different. Bottom line is, this is Kip Malek. I've been talking about the new changes to 4123.01, the workers' comp definitions, specifically the definitions that they made for the work from home folks. If you have this kind of fact pattern, I would highly, highly, highly recommend that you get a workers' comp attorney involved, whether that be our firm or any of the other workers' comp firms in Ohio. In general, I think it always pays dividends to at least consult with a workers' comp attorney. Bottom line is this stuff's complicated and complex, and usually the sooner you could get the advice and get somebody involved, the better outcome you'll have. Be that as it may, I'm going to post the link to the 4123.01 in the comments so you can read it yourself. And if you have any questions or whatever, either call our office, email me, or leave your questions in the comments, and I'll try to respond when I get to it. You've been listening to Kip Malek from Malek & Malek. Thank you. Bye.